I would like us to start. I want to welcome all of you, members, and all of us today on the virtual, our support team, members of the media, members of the public on YouTube and 408. I'm going to ask that the Secretary Tembingosi just quickly fly to the agenda and give us any apologies that we have, and then I will make the introductory remarks. Tembingosi.
Thank you. Good morning, Chairperson, and good morning, honorable members. Chair, I will
recording in progress.
Apologies, Chair, that's coming. Thank you, Chairperson. That is the agenda for today's meeting. And Chair, safety.
Mr. Ngoma, you've cut out.
Okay, sure, Chair. Yes, Chair, that is the agenda for today. And Chairperson, I only have one apology from Ms. Matrosi of the IFP. Thank you, Chairperson.
Thank you, Mr. Ngoma. One apology from Mr. Majosi, which I've seen through the email. Just keep the agenda there quickly before. So today's meeting will be focused on those two items, colleagues. The consideration of the recusal application lodged by the UDM on the evidence leader. Would have indicated when we close our meeting on Monday that we'll come back to this matter before we resume the hearings. And so it's back on the agenda for us to deal with that. The second point, bullet point, relates to correspondence. Mr. Ngoma will take us through that, but at the end of that, I will speak about correspondence that would have been sent by the EFF and progress around that correspondence. Immediately, I want to draw you to the main point and our first point. You would have received the response of the evidence leader, Advocate Nazrin Bauer. Hopefully that members would have gone through. It is not as long as the response on Monday. Just something that I just want to throw quickly to you, colleagues, that I have Ms. Fatima Ibrahim, who can assist us to read that response onto the record as one option. The other option I have Ms. Nazrin Bauer on standby to present that to us, obviously on proviso that she would not be in a position to answer questions at this stage, given that some matters are pending. I quickly want to go back to you. You can now remove the agenda, Mr. Ngoma, before I proceed. Just get the indication from you members. What are you comfortable with? Just on those two options. Do we ask Ms. Ibrahim to take us through? Do I get in Ms. Nazrin Bauer, Advocate Bauer, to take us through the presentation? That's a quick one. Or you find either way? Honorable members, you have no view on the matter?
Chair, we're fine either way, I think from my side. You can make a call on that. Fine.
Okay. Honorable Van Minen?
Sorry, I was battling to find the hand sign. We're fine. I think that Advocate Bauer will take us through. Thank you.
Okay.
I'm fine, Swela.
Thank you. We will just therefore take 2 minutes and ask Ms. Ngoma to ask Ms. Advocate Bauer to just come in and take us through. And I've explained to you the understanding of some of the limitations for her to get into discussions. Just allow her 2 minutes to join. Thank you for your understanding, honorable members.
Sure, Chair, I've asked her to join, Chair, so yeah.
Thank you. You will indicate, Mr. Ngoma, when she's in.
I will definitely do that, Chair. She's, I've just admitted her now, Chairperson. You should be seeing her on the platform in no time. Thank you, Chair.
Okay. Ndokanqola uzongixela ke xa umbona uba ungenile na. Mr. Ngoma, when she's in. Okay, thank you. I can see her.
Do the Chair. She's, I've just admitted her now, Chairperson. You should be seeing her on the platform in no time. Thank you, Chair.
Thank you. Advocate Nazrin Bauer, welcome to the ordinary meeting of the Section 194 Committee. The item on the agenda is your response on the recusal, and the second item will deal. There seems to be no response now. I don't know what.
Good morning, Chairperson. Good morning, members.
Thank you. I can see her.
The Chair, she's, I've just admitted her now, Chairperson. You should be seeing her on the platform in no time. Thank you, Chair.
Thank you. Advocate Nazrin Bauer, welcome to the ordinary meeting of the Section 194 Committee. Mr. Ngoma, please fix that, whatever that is. I think there's a very slow motion thing which is disturbing us. I was just indicating, Advocate Bauer, that we want to welcome you to this ordinary committee meeting, whose agenda is to attend to your response on the recusal. We've just discussed as members of the committee, and we understand that you would have limitations in engaging with questions. We felt it's important that you come and present at least to the committee, and we'll take it from there. Are you able to hear me?
Good morning, Chairperson. Good morning, members. Chair, are you able to hear me?
I can hear you now.
I prepared a response which was done in writing, and I will take you through the response, not necessarily verbatim, in respect of some of the issues that have been raised that may be of some concern to the members. And I will take you through what is contained therein. I was provided with both the correspondence received by the Godric attorneys representing Mr. Chumani Maxwele, and as well as the letter which had been signed by the Honourable Member Olomisa on behalf of the UDM that had been dated. I'm going to refer to them collectively as the complaints, just to make it easier. And so in doing that, I've pointed out in the submissions that the complaints essentially have the following in common. They both rely on an affidavit that had been filed in legal proceedings, although the complaints themselves don't indicate that. And they rely solely on an affidavit by Mr. Barnabas Kulu, the sole director of a law firm, B. Kulu and Partners, Inc. And he has been engaged in repeated litigation with the Department of Forestry, Fisheries and Environment. I have been on brief in that matter since roughly August of 2019. There are several applications of different kinds still pending before the High Courts. I remain on brief in that matter and have confirmed with the clients earlier on this week that they have no desire for me to be removed from those briefs. And so it's an ongoing matter, and I am responding to this with a certain amount of circumspection as a consequence thereof. Both complainants share the use of the same turn of phrase indicating a desire that I be recused in order to give me space to deal with allegations inter alia relating to alleged subversion of court processes. And I do point out that the complainants actually have no knowledge of this. They solely rely for whatever information they got on this affidavit. They appear to labor under a misconception that there exists a 407-page affidavit, which in its entirety impugns my reputation and seeks to implicate me in some sort of criminality, which I haven't quite figured out what, and to which I have some obligation to respond, whether in court or in some unspecified criminal or other process. I respectfully decline the invitation to recuse myself as evidence leader before this committee as a consequence of what is occurring in those proceedings. It does seem to me that the test of recusal, which I don't need to repeat because it's been put before this committee and explained by the parliamentary legal advisor a few days ago, would not necessitate me doing so in any event. But in any event, before this process, I am not the decision maker, nor a member of committee of this committee, nor have the complainants pointed to anything done during this inquiry that warrants my removal by this committee. Of course, the decision is ultimately one that the committee would inevitably have to make. At the outset, I raise a number of issues. That firstly, the application before court, which is currently the second affidavit on which reliance is being placed, was styled as a supplementary founding affidavit. It was actually an irregular step. It was filed, it was dated on the 4th of October, and this was in an application brought by the applicant's BXI in the Western Cape High Court. I've already indicated what my role in that matter is. There are some other 10 respondents in that matter, including the National Prosecuting Authority, the National Director of Public Prosecutions, as well as a number of other ministers that are cited. The affidavit in which I am referred is a 78-page affidavit. I've called it the Kulu affidavit in my submission, and it in the main consists of allegations, most of which have already been made in affidavits deposed to by Mr. Kulu in other applications. Those allegations have been responded to. Judges have ruled on those issues, and they have simply been repeated, and which in fact actually has no bearing on the relief being sought in the case pending in the Western Cape High Court. And those issues will be decided by that court. The remaining pages are annexures of which very few of relevance to me directly, or to the allegations that have been raised, or to this committee. Second, I do not require any space to deal with these vexatious allegations. They based on supposition, and they been put before this committee in a mischievous way and erroneously elevated to prima facie evidence in that affidavit, despite constituting substantial misrepresentations to a court. And I do point out that for a prima facie case to be established, there must exist credible evidence in support of each element of a crime, and for guilt to be proven, a prosecutor must prove the defendant's guilt as to each element beyond a reasonable doubt to obtain a conviction. Unsubstantiated allegations based on hearsay and speculation don't even meet the lowest threshold. Third, that the complainants rely on allegations made by a disgruntled litigant who continues to engage in dilatory and unmeritorious litigation. And the nub of what is going on in court relates to the repayment to a governmental department for an amount in excess of 20 million rand. And in that instance, numerous courts have indicated that that money had been unlawfully removed from departmental bank accounts and should be returned to the department. It's a litigant who has lost or abandoned in no less than 13 court appearances against the department, mostly with costs, and I'll come to those cases because I've detailed them in the affidavit, in which matters I've represented the department together with Advocate Joseph SC and Advocate Williams.
Just pause there, Advocate Bauer. Just pause there for a moment. Honorable Olomisa, I see you've raised your hand.
Chairperson, is not a point of order. Once she finalizes her presentation, I would like.
Okay. No, thank you. I noted that. Please proceed, Advocate Bauer.
A summary of the litigations that's ensued, and I have indicated that it reflects what the courts have referred to as a Stalingrad strategy to avoid liability, and is an extent. And I point out that whilst colloquially people have placed connotations to the term Stalingrad has actually been dealt with in a number of our court judgments, and it's in that context that it's being used. It is also in respect of an individual who's made this affidavit, who faces serious disciplinary charges relating to dishonesty pursuant to a complaint that had been lodged in January 2020 at the Legal Practice Council in relation to R1 million that had been paid into a trust account and which funds had been dissipated and having been spent without any compliance with the Legal Practice Act, and with complete disregard to the fact that the money constitutes trust monies. In the context of that case, his Porsche had been attached and he had refused to provide it to the sheriff. His luxury holiday home, which had been purchased under the name of an entity in which he's the sole director, had been attached because it had been largely paid for from public funds. It's a luxurious house out in Sheffield, Ballita Bay, and earnings of approximately 2.6 million being earnings due in relation to legal fees were attached as a consequence of the litigation against the department. And I then provide a table which reflect the number of instances we have had to be in court on interlocutories or matters which span from the initial application, which had been brought on an urgent basis by the department in, I think, to the best of my recollection, I think it was roughly around August of 2019. The judgment was eventually handed down initially in January 2020, and there was a Part A and a Part B, and the Part B got dealt with in different terms. And I have indicated the various judges who have dealt with various matters relating to it, including what had appeared before the SCA in respect of leave to appeals and petitions. And there are currently two that are still pending. One that had been brought in November 2021 for an application for leave to appeal to the Constitutional Court, together with a condemnation of the judgment in which they seek to petition for leave to appeal against the judgment handed down in January 2020. In respect of that, it was brought hopelessly out of time, and so the judgment's not suspended because the condemnation application has as yet not been considered. Similarly, so there is a judgment by Justice Zilwa in which he held Mr. Kulu personally liable, and an application for leave to appeal together with a condemnation application is still pending before the Supreme Court of Appeal. Fourth, I pointed out that instead of paying the more than 20 million rand that several courts have found liability to be existing from and to have been unlawfully removed from the Department of Bank accounts, the litigants have embarked on a vendetta. And I then point out that in respect of complaints or allegations that have been made, he has been aided by his erstwhile clients. In the first instance, Mr. Maxwell, who's lodged a complaint before this committee, and then secondly, Mr. Pon Gobeni, who addressed a letter to this committee in response to a letter which he received, and in which allegations were leveled against me as well. And this involved from time to time making scurrilous, vexatious, and unsubstantiated allegations through supposition and inference that in a manner defies logic, and in the instant case on the part of Mr. Kulu, making material misrepresentation to a court under oath in a manner that is unbecoming an officer of the court. The threat of a criminal complaint, which has now been put to this committee by one of the complainants, who actually bears no personal knowledge of the litigation and the circumstances in which matters have occurred, can only have one objective, and that is to aid Mr. Kulu in discrediting the departmental legal team to create grounds to embark on further litigation. 6, that the essence of the complaint in the affidavit is similar to what served before the Cape Bar Council and the LPC in 2020, 2021, probably. Those professional bodies dismissed the complaints that served before them, which complaints are essentially the same as what is being raised against Mr. Kulu, and they remain unmeritorious. And finally, for the avoidance of any doubt, I place it on record and make it clear that I have not interfered in any NPA prosecution or any investigation into criminal conduct, nor sought to frustrate any criminal investigations, nor sought to shield any person from criminal investigations, be it in relation to the erstwhile Director General, Mr. Michael Melangana, or Mr. Knox Muleli. I couldn't quite figure out precisely what the allegations were in the affidavit in respect of Mr. Muleli, but I do point out that I've had no involvement at all in any disciplinary proceedings in relation to Mr. Muleli, which, according to media reports, involved irregular appointments of curators and related charges, and not anything to do with this litigation. But I bear no personal knowledge beyond media reports. In relation to Mr. Melangana, there is a pending criminal matter in the Commercial Crimes Court in Bellville, and undoubtedly had the department's legal team in any way interfered, or myself in that investigation, the investigator or prosecutor would have taken the appropriate steps. I have not knowingly or even unwittingly, together with my team, placed any false evidence before the courts, be it by ourselves or on instructions of Mr. Melangana, or otherwise for purposes of misleading the court. Those allegations were put before the court at the time before the judges handed down judgments, and the judgment in relation to these cases speak for themselves. The factual allegations that Mr. Melangana lied formed the basis of a rescission application, and they were rejected by the court in those proceedings. We actually got the cost of 3 counsel, and in fact, there was no appeal against that judgment. As indicated in the LPC submission in 2019, consultations occurred with Mr. Mengana together with several other officials at the Department of Agriculture, Forestry and Fisheries to take instructions prior to the launching of the urgent application against Mr. Kulu and BXI. And this was the first time that I had met him. I have never had any dealings with him in a personal capacity. My role has been limited to that of senior counsel representing the interest of the client. And initially, the Department of Agriculture, it later became the Department of Forestry, Fisheries and the Environment, and members would be aware that the branch fisheries was transferred from one department to be in fisheries and forestry, for that matter, to be combined with environment and split from agriculture. And that effectively meant that there was a different Director General and Minister, for that matter, from whom litigation instructions were obtained. And that occurred from early 2000, roughly around April or May. I didn't go back to check the exact dates. And then the acting Director General, Mr. Abada, took charge of providing instructions as to the further conduct of the matter. And so at all material times in the litigation, I've been on brief for the Office of the State Attorney, and steps taken in respect of the litigation have been pursuant to instructions received. I'm not aware of any records pertaining to alleged misconduct or criminality presented before the High Court, nor am I aware of any criminal investigations pending against me, or any reports regarding my conduct that have been resubmitted to the LPC or the CBC, as appeared to be suggested. I did ascertain last week from the Bar Council, and the Secretary had indicated that there had not been any further complaints, or the complaint had not been resuscitated, as seemed to be suggested. Now, the litigation on the one hand between Mr. Kulu and BXI and the department, the NPA and other correspondence, is still pending before the courts. And as I've indicated, I remain counsel, and throughout these legal proceedings, there is information which I am not in a position to relay because I'm bound by legal professional privilege in relation to interaction, consultations, and information that had been obtained in respect of these matters. And I point out that in particular 2 matters, replying affidavits have not been filed and have been pended until other proceedings in the other courts have been finalized, specifically to avoid the incurrence of unnecessary legal costs. There's nothing clandestine or surreptitious taking place, nor was there anything unlawful in the way in which the cases were being handled. These allegations stem from the fact that the litigant has been repeatedly unsuccessful, in my view. The complaints that was initially lodged in 2020, which complained of an interference, one can see from the complaints that CC'd into them was the National Director of Public Prosecutions, Advocate Patoy, and clearly she did not regard there to be any improper conduct that warranted any steps to be taken at the behest of the prosecuting authority, or else one would have seen in the 2 years since that such steps would have been taken. Now, in respect of the complaint by Mr. Maxwell and its timing, I do not know him personally, nor to my knowledge has he had any involvement in the litigation, yet he appears to issue a threat of wanting to lodge a criminal complaint and demands my recusal before this inquiry based on a complaint premised on an affidavit of which he bears no personal knowledge and events in which he has no involvement. I find that to be difficult to understand. But of relevance is that he had been represented by Mr. Kulu in disciplinary proceedings at UCT. And the person who chaired those proceedings at UCT was my co-counsel in the litigation. That's ensued, Advocate Joseph, who presided over those proceedings. My apologies. My apologies, Chair. I didn't realize my phone was still on. I was pointing out that the complainant had lodged a vexatious complaint against Advocate Joseph with the Bar Council in October 2020, some 2.5 years after the proceedings at UCT had been concluded. And whilst the litigation had been ongoing, I had initially represented Advocate Joseph in the disciplinary hearing process, and subsequently he got other representation. Advocate Joseph, in his response to the complaints, attributed the very reason for the complaint to be because he was part of the legal team briefed by the State Attorney Cape Town in the litigation since August 2019. This was pertinently raised by him in his response to the complaint, where he indicated that Mr. Kulu had clearly incited the complainant to raise a complaint in him. Mr. Kulu's involvement was not mere conjecture or speculation, because on 29 January 2021, he directed an email to the Bar Council in which he inquired as to the progress of the complaint against Advocate Joseph, making it clear that the matter is not over in the same email insofar as it related to me. I do point out that after the Bar Council had made a decision, he had been informed that there was an internal appeal process that he could follow, and that internal appeal process had not been invoked in any way. The complaint against Advocate Joseph was extensively investigated and dismissed. I then point to Mr. Ngubeni, and I do so in the context of a letter that had been received by the committee that was tabled yesterday. And I point out that the timing of the allegations contained in the Kulu affidavit of 4 October 2022 is no coincidence, especially given that the affidavit was irregularly filed. Mr. Kulu's founding papers had been in several months prior thereto already. And that's why we say this was an irregular affidavit. And it was clearly directed at this inquiry, hence it having been brought to the attention of the UDM. I don't know how it was brought to the attention, because the UDM complaint doesn't tell us. But prior thereto, there had been no steps in furthering any complaint with either the Bar Council or the LPC. The last communication having been to the LPC in October 2021, as far as I've been able to ascertain. Mr. Kulu represented Mr. Ngubeni during the erstwhile Public Protector Advocate Thuli Madonsala's investigation, which culminated in a report in 2011 and 2012. His name was also raised during this inquiry and on documentation which was made available to the PP's legal team on 10 September, and some of which was attached to a letter to him dated 21 September 2022. He responded to the letter on 30 September 22, foreshadowing some of the very same allegations almost verbatim that appear in a Kulu affidavit that only comes out on 4 October. Those same allegations have been made in other affidavits that Mr. Kulu had filed in related proceedings, and which had been raised in several affidavits before the courts and rejected, to the effect that the erstwhile Director General had been aided and abetted by myself and Mr. Manuel, being the State Attorney on record in the matter, and having placed reliance on other allegations that courts have rejected. And so there was an indication that some of this information had been provided to Mr. Ngubeni prior to the affidavit having been filed. Now, they both seem to labor under the misconception that the client in the litigation was Mr. Melangana in some sort of personal capacity, when indeed the client was the government department whose money had been unlawfully taken. Whilst what Mr. Ngubeni does not disclose, and neither does Mr. Kulu, is that in 2020, one of the BXI bank accounts which contain the 3.6 million rand of what remained of the approximately 20 million rand that the court had ordered had to be preserved, reflected payments made to a payee with the reference Abel Ngubeni. These payments were made from funds that had been interdicted from being dissipated, and contrary to the court order, those funds were dissipated. Abel Ngubeni is the same name of the bank account holder reflected on an invoice that had been rendered by Sienego Inc. to the Office of the Public Protector, reflecting services that ex facie had been rendered by Mr. Paul Ngubeni. I then detail in the affidavit some of the payments and the dates that the reference of payments by BXI to Abel Ngubeni as a reference had been made. In my submissions to this committee, I then point out from paragraph 17 onwards the litigation background which had ensued, and I don't think for purposes of this it warrants me going into it in some detail, but I do think it's important to say that there was a judgment that that it indicated that BXI had unlawfully attached slightly more than 20 million rand from a departmental bank account, which constituted public funds, that of that amount, something like 15.5 million had been spent between the Friday afternoon when the funds had been cleared and the Monday when the urgent application was brought to preserve the funds. The courts had ordered that the law firm must pay the money back and that the sole director, Mr. Kulu, be held to be personally and jointly liable to do so. To date, this payment had not been made. Instead, the litigation continues.
As a pause, Advocate Bauer. Honorable Nola, you have your hand up.
Yes, Chair. Apologies to interject so that we are not accused of having bogus delegates in this meeting. There is a person at the back of Advocate Bauer who's busy having tea, who may be assumed to be part of this meeting. Thank you very much. If we can.
Thank you, Honorable Nola. Can that be sorted out, Advocate Bauer?
I've moved away from it. My apologies. We have electricity problems and I'm at the home of a friend, but I'm in a room all by myself in glass doors. So there's nobody within hearing of this.
Thank you, Honorable Nola, so that there's no disturbance for pointing that out. Proceed, Advocate Bauer.
I've already pointed out to the litigation before court in paragraph 18, and then indicated that the attachment of the fees had been necessary because of this depletion of the funds. The offices in Cape Town had been vacated and the sheriff had been unable to secure any property to satisfy the judgment debt. This despite the department having obtained preservation and anti-dissipation orders. In the face of such defiance, Mr. Kulu was held to be in contempt of court. The strategy embarked upon was then to impugn the impartiality of several judges in the Western Cape Division, as well as launching recusal applications against Justice Rogers, Justice Binswood, and indicating that no other judge in the Western Cape High Court could sit in matters involving himself and his law firm, and even going as far as lodging complaints against Justice Rogers with the Judicial Service Commission. And I understand that those complaints had been dismissed. I have attached to my submission a chronology of the litigation in a bit more detail to this committee. Again, I don't think it's necessary for me to read all of that. I do point out that pursuant to a request directly to the Judge President, Mr. Kulu's recusal of Judge Rogers was granted, and his matters was thereafter mostly heard by a judge seconded from the Eastern Cape. Initially Judge Smith, and after that Judge Zolwa. But and in that instance is that after Judge Smith granted a preservation and dissipation orders, his involvement, his continued involvement of the matter was objected to. Judge Smith then indicated to us that he would rather remove himself from the matter simply to ensure that it was not to be unduly delayed, because once there's a refusal to withdraw yourself, litigants go to court and they seek to go from the High Court to the SCA to the Concourt, and then it takes a very lengthy time for matters to be finalized. And so instead of us having to go through that, another judge from the Eastern Cape was, wasn't a long period of time, was appointed in his stead, and he too found in favor of the department, and in fact he held Mr. Kulu to be personally liable with his company and refused leave to appeal, and the department was successful in that instance. One of the most obvious material misrepresentations in the affidavit on which reliance is placed is the submission that the judgment of Rogers J is the subject of an appeal in the Constitutional Court. This is incorrect. In the context of leave to appeal having been denied by both the Western Cape High Court and the Supreme Court of Appeal, a reconsideration having been declined by the Supreme Court of Appeal to a petition, and an application for leave to appeal having been brought out of time to the Constitutional Court seeking condonation for its late application to appeal. In the context of where a condonation has not been granted, there is no appeal actually pending before the court, as any practitioner should be able to tell you. I then deal with the lack of substance essentially in the first complaint. I refer to the UDM complaint as the second complaint. I point out that there's no evidence prima facie or otherwise in the affidavit that reflects a contravention of the Legal Practice Act, the rules of professional conduct governing members of the bar, the provisions of Act 12 of 2004, or the Npi Authority Act 32 of 1998. In fact, no provisions of the Legal Practice Act or the conduct rules specifically have been identified that I could meaningfully respond to. The complaint also does not explain precisely what the nature of those contraventions are or how those conclusions are reached. It's quite clear that the contents of the letter are obtained directly from Mr. Kulu. There's a misrepresentation on the position adopted by the Bar Council in relation to the documentation that served before it in 2020, to which I will come to in a moment. I then deal with the provisions of the Corruption Act 12 of 2004, to which specific reference is made. And I point out, having cited the provision in paragraph 20 of the submission, that it applies to a certain category of persons, and those are referred to as a Director General or head or equivalent officer of a national provincial department. In the case of a municipality, a municipal manager, a public officer of the senior management service of a public body, a head rector or principal of a tertiary institution, a manager, secretary or director of a company, executive manager of any bank or any financial institution, any partner in a partnership, any person who had been appointed as a CEO or equivalent officer, any other person responsible for the overall management and control of the business of an employee, or any of those persons contemplated above, being any of those categories, appointed in an acting or temporary capacity. The reference to Section 34 is entirely misconceived before this inquiry, having been put before this inquiry. Clearly, the complainant had not been apprised of the fact that I do not hold any of those positions in subsection 4, and so the reporting, the remaining parts of Section 34 on which he seeks to rely do not apply to me. As far as the question of Section 32 of the Npi Act is concerned, it is headed impartiality of an oath or affirmation by members of the prosecuting authority. As I'm not such a member, I cannot conceivably transgress 32(1). As far as subsection 2 is concerned, it reads as follows: subject to the Constitution and this Act, no organ of state and no member of employee of an organ of state, nor any other person shall improperly interfere with, hinder or obstruct the prosecuting authority or any member thereof in the exercise, carrying out the performance of his or her powers, duties or functions. Now, the complainant, who appears to be parroting Mr. Kulu, nor Mr. Kulu, has provided evidence that I improperly interfered with, hindered or obstructed any member of the prosecuting authority or any member thereof in the exercise, carrying out the performance of his or her powers, duties and functions. And the reason I say that is because there is an absence of precise details of who precisely was interfered with at the NPA, which investigation that person had been engaged in that had been interfered with, the exact nature, mode, and timing of such interference, hindrance, obstruction, any improper nature of that, the manner in which such had occurred, and how this impacted on any member of the NPA in carrying out his or her powers, duties, and functions. The absence of this kind of information reflects the inauthenticity of what are nothing but vague and speculative allegations. I really see no point in dealing with wild, unsubstantiated allegations, the high watermark of which appears to be some photographs taken of documents in a lever arch file of the NPA. Those photographs, based on their quality, appear to have been surreptitiously taken as opposed to being scanned. I don't know who in this day and age takes photos of a lever arch file rather than scanning those pages into a scanner if they wish to pass it on, unless there's a nefarious purpose behind it. So this is clearly not the work of a whistleblower, but one who has unlawfully taken photographs of confidential NPA documents and forwarding it to Mr. Kulu. Blatant unlawfulness cannot be hidden under the guise of whistleblowing. Furthermore, apart from the fact that the information was in all probability unlawfully obtained, it's been so illegible that I'm not able to confirm whether it is indeed a communication that passed between myself and Advocate Cronje, and for that reason dispute the authenticity thereof. Despite the requests, I had not, prior to the finalization of these submissions, been provided with a legible copy. Now, there were several interactions between the legal representatives of DAF and various members of the NPA, including the NDPP, in relation to events arising from the Bankers matter. Given legal professional privilege that prevails, I'm not at liberty to provide details of the discussions, communications, and advices rendered. There's nothing clandestine about it, and there is no wrongdoing in cooperation between the respective legal representatives and members of the NPA. I have not been able to find the email ostensibly sent to Advocate Cronje in my sent items in order to be able to verify the authenticity of the contents thereof, but at the level of principle, I fail to understand the nature of the complaint. I do recall that there were times when emails were sent to Advocate Cronje's Cape Bar address. In fact, I have found others due to email difficulties for the NPA server. I also recall sending emails to Advocate Hofmeyer, the then acting head of the asset forfeiture unit at the NPA, from my office and in the presence of Mr. Manuel, my instructing attorney, due to the consultations taking place at Chambers. This followed on communications which Mr. Manuel had sent to Advocate Hofmeyer, which were annexed to court papers during one of the applications. And as it's a tangential issue to the complaint, but does require some background, I've put that explanation in an annexure to my response. That appeared in court papers and had been made public, and hence, in my view, I can refer to it. There seems to be some suggestion about private emails being used to make some sort of an inference of something covert arising from the use of email addresses. This is all very fanciful. I have only one email address that I use. There is some reference being made to something being common cause, that advocates do not send communications in paragraph 9.1 of the complaint, but we do frequently communicate with each other and with clients and with information. Advocate Cronje and any communication that passed by us, there's nothing untoward about it. It also happens in briefs from the state attorney with the consent of the instructing attorney, so either included in those emails or apprised thereof if the server is down, which in the last couple of years has been a huge problem within the Department of Justice. This especially occurs when that network is down. More and more in litigation, the creation of WhatsApp groups where attorneys and advocates communicate have occurred. So, and one of the most incredulous parts or assumptions that have been made is that the head of the asset forfeiture unit, which was Advocate Hofmeyer at the time, or even the NDPP, was subverted in simply mischievous speculation. There's an accusation that appears in some of the paragraphs of improper communication with the head of the asset forfeiture unit. And then on the other hand, there's allegations that the head of the asset forfeiture unit had been excluded from communication. And this simply shows how preposterous the allegations are in the affidavit on which reliance has been placed. Now, as I said, I haven't been able to authenticate the email which is attached to the affidavit, but let's assume that it's correct. And I point out that there's nothing untoward in providing a document and indicating that it should be amended to reflect a particular language style, more affair within the prosecuting style. It remains unclear how this constitutes a criminal offense or interference in any investigation. I don't even know what investigation, especially where such appears to have been provided to Advocate Mzinyati in his capacity at the time. And this defeats the illusion sought to be created that I'm engaged in some sort of private nefarious communication with Advocate Cronje, which is denied. So to the extent that there appears to be an assumption that the contents of the email reflect prima facie contraventions of the Npi Act, it falls woefully short of that. With reference to the complaint before the Bar Council and the LPC, I have annexed, provided to the members a copy of my response that at the time served before the LPC and what I had put to the Bar Council. I stand by what is contained therein and point out that the affidavit which had been forwarded to the committee is but more of the same of what served before them. There is one aspect of the affidavit. There are others, but I'm only pointing to one where it's under affidavit stated by Mr. Kolo that it was as a result of the failure of open court Bawa SC and Manuel to respond that he then directed a complaint to the Cape Bar. But this is a material misrepresentation. What actually transpired was the following. Proceedings were set down before Justice Smith for 4 days. On the very first day of the hearing, prior to the court commencing, Mr. Kulu threatened the department's legal team, saying there will be casualties along the way. A day or so later, the department was the respondent. I got up to present argument, and the date was the 24th of June. And just before I did so, an email was sent into our email boxes of the legal team from Mr. Kulu threatening myself and our instructing attorney that if steps would be taken if we did not remove ourselves from the brief. We were accused of all kinds of accusations, some of which appear in this affidavit, and we were offered a period of safe harbor if we withdraw from the case. When the proceedings were completed, I took some advice from a more senior member of the bar, and I reported and provided this letter to the Bar Council. They then addressed the letter to Mr. Kulu asking for him to respond to his actions that he had taken. His response was to file a complaint against myself and Mr. Manuel, excluding Advocate Joseph Williams, to both the Bar Council and I, as I recall, the LPC. So that's the sequence of events that occurred. I specifically was asked by the Bar Council whether I wished to pursue the matter against Mr. Kulu any further, whether I intended to take steps or whether I wished them to take steps. Bearing in mind that there was pending litigation for which I was on brief and I did not want to become conflicted, I put the client's interest first, despite numerous disparaging remarks that had been made in those correspondence against us. And I indicated at that juncture that I did not wish them to take any other steps. My instructing attorney at the time who similarly was cleared by in his department and by the Legal Practice Council, took the same view. I reserved my rights, indicating that at some point in future, I may very well decide to do so. So the 2020 Kulu complaint that went to the Bar Council, and I think it was almost the same complaint to the LPC, used words like improper, surreptitious, committing of an offense, but didn't provide any details thereof. In fact, it was alleged at the time that details could be obtained from an NPA file dealing with the Bengus matter. I, in my response, questioned how a private attorney had knowledge of the contents of an NPA file that was meant to be confidential. I do so again in the context of my response here as to how an attorney gets his hands on documentation which should be confidential and in the hands of a prosecuting authority. It remains a concern. But at the time, the complaint was at best poor and contrived and obviously a bullying tactic. Because it was so poorly constructed, it didn't warrant substantive input from myself on the allegations contained therein. But I nevertheless provided a response to the extent that I deemed necessary. The complaint of the 30th of July was so convoluted, one couldn't make proper sense of precisely what the complainant wanted to achieve, other than the obvious, which was our removal from these proceedings. And one of the accusations made was that we were seeking to hide behind the various judgments now as a form of justification. Now, as far as I was concerned, these accusations had been made on affidavits before the court. We were engaged in litigation that was pending. and it should have been dealt with by us circumspectly. But once those judgments came out, they were binding. And there was just no unlawful, unethical, or criminal actions to answer for. The judgments spoke for themselves. And to the extent that allegations of that nature were made on affidavit and dealt with, there was no conclusions reached in those judgments of any false evidence having been put before the court or reached, or that legal teams had knowingly or even unwittingly placed false evidence before the court. So simply because Mr. Kulu was dissatisfied with the findings of the court, and despite several judges having almost reached the same conclusions and left with little recourse in the cause, Mr. Kulu now appeared to be litigating these allegations against the legal representatives under the guise of complaints to the Bar Council and the LPC, in the hope that it would give him a reason to go back to court. There was also no frustration of any prosecutorial process. The NDPP, as I indicated, was copied. She would have had knowledge of the cooperation that ensued. She would have been aware of the matter and my involvement, as well as the communications that ensued with Advocate Hofmeyer in his capacity, then as the acting head of asset forfeiture, because the latter appears to be the case from the very memo being relied on, of course, assuming that that is indeed authentic, that is addressed to the NDPP. So the high watermark of this affidavit on which the complainant seeks to rely is unsubstantiated allegations of unlawful and possibly criminal actions. That's what the Kulu affidavit says. The complainant to this inquiry takes the statement, possibly criminal actions. He who knows nothing about the allegations in question. And he then has the temerity to tell this committee that it must be elevated to necessitating a criminal complaint, and appears to reach unsubstantiated conclusions that there is indeed been contraventions of certain laws and codes of conduct. He goes far further than what the affidavit before the courts do, without having knowledge of anything. So it's also not correct that I had not denied the allegations made against me in my response to the LPC, as I expressly stated in paragraph 33 thereof, that there is no basis upon which to conclude that any false evidence was put before the court and or that the legal team knowingly or even unwittingly placed false evidence before the court. I specifically, in my submission to this committee, refer and quote in paragraph 48 paragraphs and excerpts from my submissions to the LPC. I point out in those paragraphs that regarding the concealment of documents, the court found that DAF and Mr. Melengana were obliged to place documentary evidence before the court, which in their view were relevant to the issues to be decided, and that the fact that there may have been other related documents which they regarded as irrelevant does not on its own give rise to an inference that these documents have deliberately and fraudulently been concealed from the court. In this regard, I refer specifically to paragraph 79 and 93 to 95 of the judgment of Smith J. In conclusion, there is no unethical or unprofessional conduct on my part or the part of the DAF's legal team. In amplification, it may be apposite to advise myself that myself, Advocate Joseph, and Mr. Manuel consulted with Mr. Melengana, and I repeat what I've already told this committee about how we came to be in this brief. And I point out that none of the judgments made any findings that support the accusations of the complainants, and in fact that all three judgments had made cost orders against the applicants in those matters. Whilst the Bar Council in their response did not seek to refer to the judgment of Smith J to make a finding in relation to what was put before the court, I, in my submission to the LPC, indicated that I respectfully disagreed with the Bar Council in that approach, in that it was evident from the judgment of Smith J that the court had no cause for complaint, that the evidence placed before it had been false, belying the allegation that the team had put false evidence before the court knowingly or otherwise. In my view, the Bar Council should have informed the complainant that based on the judgment, there was no merit to the first charge, as was the case on the substance of the case. Mr. Kulu is thus not being truthful when he says to the court that there had been no denial of the allegations. I also explained to the LPC and provided reasons why there was no merit to the complaints. I personally have no knowledge of the nature and extent of the investigations conducted by the Bar Council or the LPC in relation to this complaint. But from my past experience, given the thoroughness with which disciplinary processes is ordinarily dealt with at the bar, my own experience, I would be very surprised if the matter had not been dealt with and closely scrutinized by a more senior member of the bar, or that the Bar Council had not thoroughly considered the complaints given the nature of the complaints. I understand that Mr. Kulu or PXI did not seek to exercise any appeals, and they now raise allegations in an affidavit irregularly filed on 4 October 2020, which has every appearance that he seeks to create mayhem in this inquiry and then use that as a basis to impugn my credibility in further court processes. My last communication that I received from both the council and the LPC indicated that I had not transgressed conduct rules of my profession, and to all intents and purposes indicated that the complaints were meritless. It remains so that there is no further substantive evidence in the most recent Kulu affidavit to give rise to any fresh consideration of the complaints or that warrants reconsideration, but the decision lies ultimately with those professional bodies, and should they opt to do so, I will at the appropriate time deal with whatever comes. In the course of the complainant's letter to this inquiry, there is also some aspersion made against the Office of the State Attorney, pointing out that that the State Attorney is also, the Office of the State Attorney Cape Town is also implicated, and that it's that office that had briefed us for purposes of the inquiry. My attorney, who I deal with at the State Attorney's Office in respect of the inquiry, is Mr. Lawrence Ngwenya. As far as I know, he has had absolutely no involvement in any of the Kulu PXI matters. And so I think that the allegation is made out of ignorance as to how the Office of the State Attorney actually operates. I find that it's also mischievous, as I point out in paragraph 56, to say that to this committee that there are records pertaining to misconduct on my part serving before the High Court, or to hint or suggest that there are pending criminal investigations that I'm involved in or have been implicated in, when this is not the case. One would be concerned that members of the public, like the complainant, would have knowledge thereof, but not the people directly involved. It appears to be nothing more than a ploy for reasons I've already stated. It's for the aim of having a knock-on effect on derailing the inquiry. I say that there are no records reflecting any misconduct before the court. Criminal investigations are in any event done by the police and not the prosecuting authority. And if I want to take it and be more pedantic, there isn't one accusation even created that says there'd been any conceivable meddling with SAPS investigations. One would expect the SAPS investigation to precede a prosecution. So the allegations are again unsubstantiated and denied. I then deal with some of it I've repeated in respect of, I've already dealt with some of the allegations in the affidavit that appear in complaint. I've already referred to, and I'm not going to repeat it. I do point out that the complainant's conclusions are entirely fictitious as to the reasons for the communication with Advocate Cronje. And even if the contents of that illegally obtained email relied on was correct, it doesn't point to a transgression. The speculation ranges from personal email accounts to conjecture. I've already dealt with that. Then again, in paragraph 9.3 of the complaint, there's a reference to interference with other officials, none of whom are properly identified. And this refers back to a memorandum, which refers back to communications that ensues with Advocate Hofmeyer. And as I've already indicated, and I referred to as an annexure to my submission, Mr. Manuel had explained the communications with Advocate Hofmeyer in affidavits, and I've summed it up in an annexure before this committee. But there's nothing sinister about it. But what is sinister is the need to elevate the reference to Advocate Hofmeyer in the memo to other officials in plural to give a deliberate appearance of a deliberate misrepresentation, that there are more than one NPA official being referred to when the memo simply refers to Advocate Hofmeyr. This in itself makes one question the legitimacy of the complaint being made. Again, I do not accept that the memo is indeed authentic or lawfully obtained, and I have no way of authenticating it. So in the absence of details as to precisely who is allegedly improperly contacted at the office of the NPA, or complete details of the report of the NDPP, I'm not able to deal further with some of the allegations in the complainant's letter. I do point out that at no stage in my interactions with any members of the NPA in the course of this brief have I engaged in impermissible or unlawful behavior to obtain information. There is no reference to precisely what this information was that was obtained, nor is Mr. Kulu sought to strike out any evidence in any of the court applications on the basis that it had been unlawfully obtained. I deny that I had at any stage misled the court. There seems to be a bold averment made to my standing, character, and conduct. Again, speculatively endeavoring to give rise to what I refer to as smoke and mirrors. And if one take a step back and think about this, it would mean that in the context of any future Section 194 process, anybody can raise unsubstantiated allegations from unrelated, incomplete proceedings and seek under the guise of speculation to have either the chair or any member or the evidence leader removed. One only has to think about that and that averment to know that such must be rejected. As they wander into the world of conjecture, supposition, and theories with no foundation in law or fact. There is no allegations which in fact impugn my standing, character, conduct as an advocate in practice or otherwise, to which I, in a meaningful way, have to respond. And the reliance on his erstwhile attorney's affidavit in this context, as described in the submissions I make to this committee, is hardly a legitimate basis in which those allegations can be elevated to being bona fide accusations that would imperil the inquiry. To do so would be an unwise and dangerous precedent for parliamentary committees. Bear in mind that this comes from a legal practitioner who had no qualms in threatening his opposition's legal team during the process of court proceedings. And I repeat that because if there had been a legitimate basis to raise a complaint against the legal team for the department, the way to have done that would have been to properly and openly done that in open court, with submissions to be addressed to the court in the context of the case for a judge to deal with, rather than sending surreptitious emails behind the judge's back, because that's precisely what occurred. So if I turn to some of the submissions made in the Kulu affidavit, which is not dealt with in the complaint, I point out that it's pretty obvious that the allegations against me was an afterthought made in a further affidavit that was filed. Secondly, I'm not party to the litigation. I may be counsel, but I do not have any obligation individually, nor do I have any right individually to answer those allegations in the context of that court application. Whatever answering papers is to be drafted, it will be in accordance with the department's instructions and in a manner which serves the best interest of the department, not me. Most of the affidavit, in any event, is a regurgitation of what had been previously stated in other affidavits. So much of the 78 pages was a cut and paste job, probably done rather urgently to put something out in the public domain of what had been answered and put up in other affidavits before the courts, and they bear no relevance to the relief being sought before that court. Further, I point out in paragraph 71 that at the time the allegations were made in 2020, there was, to the best of my recollection, no credible information to indicate that there were pending criminal investigations against Mr. Melengana. This was dealt with in an affidavit filed by Mr. Manuel. I have no personal knowledge or involvement in the matter currently, criminal matter currently pending against Mr. Melengana, but it appears from reports that it relates to supply chain management irregularities. I understand that summons was issued in 4 March 2022 in the Bellville Regional Court and reflects that the investigating officer is a Captain Daris and the prosecutor is a Seroto. That matter is being dealt with in the Western Cape. I'm not acquainted with either of them, though clearly the prosecution would fall under the jurisdiction of the Western Cape Director of Public Prosecutions. The charges attached to the summons do not include a charge for perjury in relation to the affidavits filed in the BXI Kulu matter, and more pertinently, it is highly unlikely to have involved either Advocate Cronje or Advocate Hofmeyer. I think by the time the charges would have been formulated, Advocate Hofmeyer may very well have left the employ of the NPA. And the suggestion that these charges could not have been brought until after they had left the NPA is but a figment of his imagination. Given the roles that they played at the head office at the NPA versus a prosecution occurring in the Western Cape. But absent details as to how precisely there was manipulation and subversion of court processes in the Bengus matter, the mere say-so of Mr. Kulu does not constitute a prima facie case of unlawful conduct. Communications with Advocate Cronje and Hofmeyer were not secret or unlawful, and the conclusions drawn are spurious. Suggestions that communications were unsanctioned and undisclosed is speculative. As I've explained, it was at all times above board. There is no affidavits beyond Mr. Kulu saying so that the communications were unsanctioned or undisclosed. With reference to paragraph 25, Mr. Kulu refers to documentation provided by a whistleblower who allegedly feared retaliation at the hands of their superiors in the event that same was realized and presented in public records. I have no knowledge of what he is referring to, but I reiterate that the annexures to the affidavits are photographs taken of what can only be regarded documents in the possession and under control of the NPA, to which I've already referred. This is not the work of a whistleblower. A whistleblower must have something to gain or something to hide or some reason why this is done. This is the work of somebody who illegally obtained information and provided it to Mr. Kulu. And this illegality is being hidden under the guise of whistleblowing. And this is concerning given the nature of the work the NPA conducts. In any event, for reasons I've already indicated, I dispute the authenticity of the documents attached to the affidavit if they are indeed. Personally, I'm not able to say whether these are not. But there is an irony that Mr. Kulu is suggesting that an internal and confidential memorandum to the NPA was provided to me outside of conventional communication channels. Not sure what precisely is meant by conventional communication channel, but nevertheless, it's denied. And yet he is relying on NPA documents which he unlawfully obtained clearly outside these communication channels and in contravention of the very legislation that is being relied upon. I do point out that I was not provided with a memorandum of Mr. Mulele and Advocate Msinyati by Advocate Cronje. The speculative and uncorroborated statements that documents was leaked to me is also not supported by any evidence. It is to be noted that despite the thousands of pages of documents that had been provided by Mr. Kulu or BXI during April 2019, there was not one page that reflected an authorization being granted to him to act as an attorney of record for the NPA in court proceedings at the time he obtained a court order at the Western Cape High Court. I don't say anything further about that matter because it remains a matter subject to litigation, and affidavits are still outstanding in that case. The other application to which is referred in, so in light of the condemnation application that I've already referred to pending before the Constitutional Court, my instructions were not to conclude the other affidavits. And I raise this in light of the allegation that we had driven the litigation as a desire to write fees. At every stage thereof, we have acted on instructions and there have been several consultations with client representatives who at all material times have provided instructions on how matters should be dealt with. The accusation that as legal representatives we have generated litigation simply to write fees is both insulting, without any factual basis, and belied by the very fact that we've not lost any of the cases to date. I do point out that in almost 24 years of practice, I have fortunately not reached the point of having to manufacture briefs. In fact, the very matters pending have not been answered because it would have resulted in the department having to incur costs without knowing whether that such could be recovered from BXI and Mr. Kolo. So there's a risk to litigating for the sake of litigating without any cost in that regard. There's also a matter pending before the Pretoria High Court that has not been finalized because of both BXI and Mr. Kolo's inability to provide security for the vexatious litigation that had been brought. So to the extent that any information was provided to the NPA by myself, this was done on request. To the extent that there are allegations that I personally sought to obtain information from the NPA in a surreptitious manner with some unlawful motive in mind, this is denied. No personal benefit accrues to me to do so, or none has actually been pointed out. In order for such to have been surreptitious, it would have meant that it was done without the knowledge of the NDPP, and there's no evidence thereof in Mr. Kolo's affidavit to that effect. To the extent that it is alleged that I did not deal with allegations as contained in this affidavit in respect of the LPC, a copy of my response to the LPC is provided to this committee. As already indicated, given how poorly the complaint was drafted, not all allegations even warranted a response. As far as allegations in court papers is concerned, those were dealt with in the court applications and the judgments deal with them. There seemed to be an allegation somewhere along the line that Advocate Cronje may or may not have had involvement in the preparation of any argument. I can unequivocally state that to the extent that there is such an inference draft indicated she had no involvement in any of the papers filed in the court in relation to the BXI Kolo matters. And so I further then point out that to the extent that the affidavit seems to draw the inference that that it was the departure of Advocates Cronje and Hafmeyer from the NDPP that allowed for criminal proceedings to have ensued against Mr. Melengana. I find that to be highly fanciful, but again, that may be something that the NPA should be answering, not me. The far-fetched conclusion is, I find it to be wild and defamatory in the affidavit, but in the absence of any evidence to reflect that, I can't respond to it. So in a nutshell, there is no evidence actually of any inference in any NPA process or of any behavior that warranted a response of any court. Multiple court cases have indicated that I've not found that to be the fact. And the ad hominem attack simply served to illustrate the lack of substantive merit in the law on these applications. I have sought in my submission, which I haven't entirely read out to this committee because some of it is repetitive in the context and the way it was answered, but I have sought to deal with the main allegations. Given the repetitive nature, I may not have dealt each paragraph in turn because it becomes tiresome, and I didn't want this document before this committee to be unduly lengthy, but I think that the gist of it has been dealt with. To the extent that there's any specific allegation impugning me in any way is denied, and in relation to the complaint and the affidavit, in my personal rights are strictly reserved. With reference to the request from the Honourable Member Honomisa dated 12th October, and to the extent that any specific contents of that seeking my recusal, and again, I'm not sure whether, well, I don't think recusal is actually the way to deal with it, because a recusal would mean some sort of bias or conflict of interest within the committee. It's probably more accurately my removal, if I understand the complaint, out of some concern that it would taint this process in any way based on what had been brought to the UDM's attention of me being implicated or embroiled in legal proceedings leading to some sort of prosecution. And there is reference made in that complaint to section 41(6) of the Npi Act. And I make it quite clear that I'm not embroiled in legal proceedings, I'm not party to litigation, and I'm not implicated in any crime beyond Mr. Kolo Spuri's allegations. I'm also not implicated, as the UDM may have been informed, in the entire 490 pages. Quick perusal indicates that probably less than 5% of the 409 pages actually deals with this. I'm not quite sure why it should go to the Judicial Service Commission, because I don't think it has any jurisdiction to look into allegations, unless it's being suggested that the judges in the cases on which judgments had been rendered had in some way acted unlawfully that warranted the Judicial Service Commission to look at it. As far as section 41(6) of the Npi Act is concerned, there are two of the jurisdictional facts of the provision that I draw reference to. It basically says that notwithstanding any other law, no person shall, without the permission of the National Director or a person authorized in writing by the National Director, disclose to any other person any information which came to his or her knowledge in the performance of his functions, contents of books or documents, record of any evidence at an investigation, and for purposes of performing their functions when required to do so by an order of court of law. Any person who contravenes that would then be guilty of a offense. Now, the jurisdictional fact remains that the disclosure had to be without the permission of the National Director or a person authorized in writing by the National Director. There's no allegation that in that regard on the affidavits that indicates anything that the National Director had either not given permission or that the person would so communicated without permission. That must be there before section 41(6) can be invoked. Further disclosures may occur even without such authorization or permissions when done for purposes of performing his or her functions in terms of this act or any other law. Now, the two persons whose name come up is Advocate Cronje and Advocate Hofmeyer, both are senior members of the NPA. And the Kulu affidavit casts aspersions on them, but presents no evidence that they had at any stage acted outside of the performance of their functions and duties. On that simple premise, the jurisdictional facts required, as required by the Npi Act, doesn't even get elevated to the issue of what is required for a prima facie case. So the allegations of any subversion or manipulation of court processes are without merit and denied. My professional bodies have investigated it and dismissed it. Mr. Kulu might not like the basis upon which they were dismissed, but again, in respect of the bar, he didn't take any further steps, and to the extent that he may have communicated subsequently with the LPC, they have certainly not communicated with me. Finally, I point out that there's no criminal investigation that I'm aware of to which had occurred involving me. For reasons already elaborated, it's not clear whether the UDM had been apprised when they were provided with us that the affidavit brought to their attention was nothing more than an untested and untrue affidavit from a disgruntled litigant who repeatedly embarks on unmeritorious litigation or stalled litigation to avoid paying public funds back to a department that had been unlawfully removed. The motive to discredit me before this committee appears to be a stepping stone to create further grounds and further litigation in that instance. I then point out that the document only proves what is written, but not the truth of what is contained therein. Well, that is usually a phrase used by courts in respect of documents. In this instance, in respect of this affidavit, it seems to be apt to draw the same analogy. Thank you, Mr. Chair.
Thank you, Advocate Bauer, for your presentation. We're happy that you could easily be available to take us through this. It was necessary that we listen to your presentation, and I would have been patient to allow you go through that. Thank you for that. Honorable members, having listened to that presentation, I am going to move back to you, starting with Honorable Olomisa, who would have indicated much earlier on that he does want to come in. I just want to invite members to indicate those that want to contribute by comments, clarities, with the limitations that I would have indicated up front. But also as you do that as members, you respond to the question that the committee must take a decision on. So it will be Honorable Olomisa, followed by Honorable Mylan, who has his hand up. Honorable Jane Mananiso, Honorable Nola, Gondwe, Dlakude, Van Minen, Maneli, in that order. Thank you. Honorable Olomisa.
Thank you, Chairperson, colleagues, and Advocate Bauer. My apologies in the Sendleleni Mhlekazi. I've just stopped. I'm on my way to the House for debate this afternoon. I mean, to my office in Parliament, or to prepare for the debate this afternoon. My take on this is that at this stage, I will just focus mainly on procedural issues, trying to map up the way how to solve this problem. Thank you, Advocate Bauer, for the detailed presentation. The committee has, however, a duty to hear both sides of the story. So they must also invite, therefore, both complainants after giving proper notices. A statement must also be obtained from Mr. Kulu to give his version. She has made serious allegations of dishonesty against Kulu. The committee cannot be seen to give an invitation and opportunity for an oral presentation only to Advocate Bauer. I repeat, oral invitation without affording the same opportunity to those who have accused her of wrongdoing. We cannot just hear a defense without hearing the accusations being responded to. All right, we put it this way. The agenda only deals with the complaint of the UDM, but she has now allowed, or rather we have allowed her to deal with separate complaints by Makwele and Gobeni. Therefore, I think we must hear the side of those who she has mentioned. A decision of the committee taken after only hearing one side will be meaningless and a waste of time. So that's my submission, sir. So it's so far it's still about procedures, but if one is
invited in future again, I will dwell more on because my concern was the letter or the correspondence or the allegations that she is working with some NPA personnel. So we will deal with that later. Thank you very much. Zawubaleka ke Nkosi, ndiya ehouse.
Thank you, Honorable Misa. Honorable Mailam.
Thank you, Chairperson. And let me start by thanking Advocate Bauer for her very, very detailed and comprehensive response to these allegations. I think it helps us immensely to put this into perspective. Let me start where Honorable Holomisa left off, and that's about procedures. So first of all, we need to acknowledge that Advocate Bauer is not the person of interest to this committee. In other words, she is not the person who we are here to consider whether or not there are impeachment proceedings that need to be followed. And so as far as that is concerned, she is not a person who we should be investigating or taking further action against. I want to start there. The second issue that I have is that the allegations that are made by the various, the word that Advocate Bauer used was complainants, are completely unsubstantiated. In other words, they're basically allegations that are thrown out there in the hope that something will stick. There is no evidence provided. There is no supporting documentation. There is no reference to cases or case numbers where charges have been laid or anything like that. They are mere allegations. And it is not our job as this committee to consider those allegations. The third point, and this is something that Advocate Bauer elucidated quite well, is that she is not the decision maker in this matter. In other words, it is her job to present evidence. It is her job to lead the witnesses. It is her job to collate information and present it to the committee. Her other issues that she may be dealing with outside of this committee are absolutely irrelevant to our considerations, our deliberations, and whether or not we reach a decision for or against the public protector. And so I find it bizarre that this recusal application is even brought, because it is not something that materially affects the outcome of the process which we are underway with. Advocate Bauer is perfectly competent to continue as the evidence leader. She's well qualified. She has done a sterling job so far in dealing with the matter. And I find that the allegations against her in no way, shape, or form prevent her or preclude her from continuing as the evidence leader, and should not be entertained by this committee. Thank you, Chair.
Thank you, Honorable Mylan. Honorable Mananiso.
Thank you, Chairperson. Let me start by welcoming the presentation. And as well, one would want to agree that indeed the response from Advocate Bauer is very reasonable, and as well, it deals with facts. So one would want to clearly indicate that I actually reject this particular submission of the recusal. And I want just to indicate and comment, Chairperson, that in this portfolio committee, actually, this committee, we are being told about using the majority vote. However, we cannot be delayed by the minority. Yes, we do agree that sometimes majority can be wrong, but the minority cannot delay the majority. By so saying, Chair, one wants to reject this particular application. Thank you.
Thank you, Honorable Mananiso. Honorable Kolangola.
Thank you very much, Chairperson. Let us again accept the presentation or the response by the evidence leader, Advocate Bauer, SC. Chair, let me echo the views of some members who have already spoken before me. In that, Chair, I equally move that the committee reject the application for recusal by all the applicants. The reason for me to move that way, Chair, are as follows. One, Chair, if you read the application by the UDM, it has got 7 paragraphs. 4 of those 7 paragraphs is basing its own wisdom on allegations. Paragraph 2, paragraph 3, paragraph 4, paragraph 7. You read the following words: allegedly, allegations, alleged. So it seems to me that the entire application is based on the wisdom of allegations. And from where I'm standing, Chair, we are all citizens in whatever profession that we belong to that are protected by the Constitution, which is Section 35 of the Constitution grants all citizens a right to be declared innocent until proven guilty, which is affectionately known as the presumption of guilty. And Chair, whatever piece of legislation or whatever prescript of law or whatever provision of law that we may get to the contrary would actually be invalid and unlawful, because equally Section 2 of the Constitution declares or proclaims the Constitution as the supreme law of the country. So any conduct or law against it is unlawful and invalid. So that's the first Chair reasoning that which I think from me, the application from the UDM does not meet actually what one would have expected from a recusal application. Chair, there's another issue here. That the second application, whether by Kulu or Makwele, is solely based not in the proceedings of this inquiry, but on the character and conduct of Advocate Bauer. Now, once you provoke the character of another person, you are in turn provoking your character being actually judged as well. If, Chair, we can't have Advocate Bauer as the evidence leader on the basis of the character, the conduct, in all the matters that are stipulated from the application, on the basis of what is being said here, what the response is bringing us is the character of the applicants as well. So if we can, at a given stage, say, okay, because of this conduct and character that is stipulated from the application, therefore, Advocate Bauer does not stand credibility to be part of the inquiry and all that. It equally means the people who applied as well, because their character has been attended to as well in the response, do not have a standing or a credibility to speak on matters of character and conduct. So I'm saying, Chair, what I'm reading here is the antithesis of what is being brought in the actual application. Chair, the third issue which I wish to raise is the matter of whether will we condone the application that only deals with the character, the disputed character of Advocate Bauer, that has no bearing in the inquiry. it would have been easy for the commission, for the inquiry committee to deal with these matters had they reflected what is happening within the proceedings of the inquiry. Now, because these are matters outside the jurisdiction and the operations of this inquiry, it makes us not to have much issues to raise as it relates to what has been pointed out. Advocate Bauer says in the response, she disputes that she has committed any interference with the criminal prosecution, the NPA prosecution, or frustrated any investigation. She equally goes and says she is not aware of any pending matter against her before the High Court. So that actually insinuates that what is written in the application exists only in the figment of the applicant's imagination, was there is a complete denial of what is being accused or alleged in the application itself. There's an issue, Chair, which I thought I would maybe seek clarity, but you said must not seek clarity, but it's fine. But part of what I've noted, which is not detailed at length, is the issue of the relationship between the Ngobeni person who reflects in the application and the Sianejo attorneys that are representing the public protector in these inquiries. Maybe, Chair, if it's possible, or it won't hinder the progress of this committee if just one part, Advocate Bauer just elaborates what does she mean when she speaks about an invoice that involves Ngobeni and the Sianejo attorneys that are representing the public protector in this inquiry. Just 2 paragraphs, Chair, so that we are better seated as the committee of what is it that she's trying to communicate with the committee. Chair, Advocate Bauer says in the response, the last communication she received from both the Cape Bar Council and the LPC indicated that she did not transgress the conduct rules of the profession. So meaning where she is seated, she has been communicated from the profession, both bodies, that the professional bodies did not find any transgression from her part in relation to what is being alleged in the application. The UDM Chair speaks about her being embroiled in many litigations, and she is disputing that she's embroiled in any form of litigation. She goes further and explains her involvement in terms of her being instructed by the Department of Environment, Forestry and Fisheries, which I think in that part she is executing her role as an advocate of the High Court, not as a suspect or a respondent or any other form. Now, Chair, from what I've read, from all angles, from the GG attorneys, from the UDM, the response from Advocate Bauer, I am of the view that this committee can continue to be derailed to do its work by allegations, by accusations, where there is no concrete and substantive submissions to it. Was the problem, Chair, is that if we continue like this, of course we must be transparent, of course we must be open, of course we must allow even communities to play their own role, as this is a matter of public interest. But I think we must at some point be patient with the process and not bring some frivolous applications that are meant to delay this inquiry. I'm saying this, Chair, because in the detailed response from the evidence leader, she goes to an extent of detailing how Mr. Xulu is a character of, is a Stalin grade character. There are things that are, I won't repeat, Chair. I mean, I won't repeat issues of attachments of properties and other things. But there is that character that is revealed of the applicant. So there are a lot of things that are being revealed to the committee, Chair, but I don't think some of the detail will further go will further go deep into them. So I move, Chair, that the recusal application be not accepted, and the committee proceed with its work, and this be communicated with the applicants in due course. Thank you very much, Chair. Oh, Chair, sorry, one issue, just one issue. I don't think, Chair, it will be adequate for the committee to call any other person outside this committee or this inquiry to come and do an oral presentation. Mr. Kulu, Mr. Makwele, Mr. Ngoben, and all those people are not part of this inquiry, and therefore we want, I don't think it would be adequate for us to call them to do any presentation in this committee. We have received the affidavits and the application. Thank you very much.
Thank you, Honorable Ngola. Honorable Mimi Gondwe.
Thank you very much, Chairperson. Let me also start by appreciating the effort that Advocate Bauer has made in terms of taking us through her response to the recusal application. I also share the sentiments of Honorable Ngola that there is really no need to call anyone outside of this committee and who will add relevance, who will not add relevance to the work of this committee to come and speak on this matter. Chairperson, I think it's also important for me to state from the outset that I support Advocate Bauer's decision to decline this invitation to recuse herself as evidence leader, in this inquiry. Chair, the matter that is being used as a basis of a foundation for her recusal application is so far removed from the work of this inquiry, which inquiry has only just recently started with its work. Advocate Bauer has just confirmed to this committee that she's been on brief in relation to the matter raised in the recusal application since 2019, and there are several pending applications in terms of this brief. As such, I want to repeat that the matter concerned not only predates the work of this committee, but is also very complex in nature and has no bearing or relevance to the work of this committee. That have been said, Chairperson, to date, in my opinion, Advocate Bauer has not so much as uttered or done anything that would warrant or necessitate her recusal from this inquiry. If anything, she's conducted herself with the professionalism and the decorum that is expected of someone of her standing as senior counsel of the Cape Bar and a senior officer of the court. I also agree with her assertions in the response to her recusal application, namely that she's not the ultimate decision maker in this inquiry, and neither is she a member of this committee. Her role is merely limited to that being of evidence leader, an evidence leader that, I might add, Chairperson, that leads evidence that can either exonerate or implicate the public protector. I would therefore request that we move on. We don't even, so much as after this give any more thought to this recusal application, and we carry on with the work of the committee. We're just about to listen to the last of the witnesses called by the evidence leaders, and thereafter have the PP lead her witnesses. And we really want to get to the next phase of the work of this committee. Thank you, Chairperson.
Thank you, Honorable Gonde. Honorable Lagude.
Thank you very much, Honorable Chairperson. Good morning to you and my colleagues and the evidence leader, Advocate Bauer. Thank you very much, Advocate Bauer, for your detailed response to this recusal application. Honorable Chairperson, I will not waste time of this committee, but I want to agree with my colleagues on what they are saying, that as a committee, we must reject this recusal application because there's no basis for this recusal application. Advocate Bauer gave us a detailed response of which we are satisfied with, so we cannot agree with this recusal application as a committee. We support the response given by Advocate Bauer, and also we are looking forward to continue with the work that is before this committee. So I fully agree. Honorable Ngola also went into details with regard to his response, of which is a correct diagnosis of what transpired here. Thank you very much, Honorable Chair.
Thank you, Honorable Lagude. Honorable Benedicta van Minen.
Thank you, Mr. Chair. I really want to agree with the vast majority of my colleagues, in particular the Honorable Dr. Gondwe. I also want to point out that the Honorable Holomisa pointed out that we have to have both sides of the story. That's exactly what we have. There is a rescission application, which Advocate Bauer more than adequately answered this morning. We have heard both sides. I think that this committee really has no choice at all except to dismiss the recusal application. It is ill-founded. It does not have any basis in relevance. Some of the facts certainly appear to be rather dubious and to be stretching. And I think no case has been made at all. I also think that it needs to be pointed out that those of us who have worked in practice in law are very aware of malicious litigants. And unfortunately, it seems to be a discipline which does attract its fair share of people who seek to possibly misuse the process. And I think in this particular case, what we need to do is dismiss this and move forward. We have now spent 3 months dealing with direct evidence. We're now at a situation where we indeed have a last witness to hear, and then we will be dealing with the public protector's side. And I think we need to move forward to do that, not just for this committee and for Parliament, but also for the good of the people of South Africa. Thank you very much.
Thank you, Honorable van Minen. Honorable Maneli.
Thank you, Chair. Greetings to honorable members and Advocate Bauer, who has presented a response. Firstly, Chair, on my part, it is to just indicate that indeed this is a response from Advocate Bauer, and therefore accept the decision of Advocate Bauer not to recuse herself as evidence leader of the inquiry, as there was no single ground given that proves her bias in the way she has led evidence in this inquiry. As we are now almost one witness left to the on the evidence led on charges brought against the public protector. I think for me that's important. That we're almost at the tail end, and I want to bring this point later about time and space. But the second issue, Chair, is that there's not been any evidence to prove any ethical issue which could be raised to the effect that it would taint the inquiry just even from a point of morality, which is very difficult to prove. But there's no such a thing that has been raised. So therefore, I second that point that we accept her decision. I think for me that's very important. It's her decision, and she has given a comprehensive response in that regard, and the committee accepts that. And accepting it, I want to then come back to that point, just to underscore this point about time and space. Because when you listen to the presentation, and also having read the document, we are talking about a matter that predates the functioning of this inquiry. And Advocate Bauer is not elected into this committee. She came through an appointment process as an evidence leader. But this has been made public because our meetings are public. Therefore, from a time and space point of view, if there was any matter that her being brought on board would taint the inquiry, genuinely that matter would have been raised at that point, not when evidence has been led and so on. Of course, it is when you read the report in detail that we are at a point where some of the characters have been pointed not long ago, as pointed in the report, that there's this invoice here that relates to this character. And unfortunately, it is this character that is also a beneficiary in another transaction that happened after a court order has been made to freeze the monies that would have been there. So now I think, Chair, if we take then that into account, you can only come to that conclusion that she makes, that in essence, we are not even party to the matters that predate this committee, but it can only be brought to this committee in order to derail the committee from doing its work. And we even have suggestions that we then bring people that are involved in another matter in another court. And then we become some tribunal that now starts looking at that matter which we have no powers to deal with. And therefore want to suggest, Chair, even for the future, that probably theory has not helped us much because we thought everything would be confined to what is the inquiry. But as you know, if theory fails in that regard, events will teach you. The events are beginning to teach us that we can get out of what we are mandated for if we do not also screen better. And I want to make the point on why I say screen better. Immediately, there's a reference to a criminal matter before courts. The first point really would have been, do you have a case number? So that at least we know there are charges brought against a person and these are tried in a criminal court if it's a criminal matter. So I don't want us to then do it differently by then saying it's an issue of giving the other side an opportunity to be listened to try and build up a criminal case we are not even aware of in that regard. Same to say that as a citizen, over and above being a member of parliament, but just as a citizen, and I would want to say this with a great deal of respect, Chair, that my assumption may be correct that even the UDM may have not been aware of the details that are being given to us now, because if they were aware, I would be worried as a citizen of the country that you have a situation where public funds are being recovered. And there's a whole lot of story around that. And then we get involved in a way that we ignore all those things, but try and compromise an inquiry that seeks to talk to accountability by institutions that need to protect a public. So I'm just saying, for me, that's something I would say, as I said, respectfully, it's an assumption I make that these were just wild allegations. They may have not been looked at, but if this detail would have been known, that you may actually get into a web of characters that are seen to be implicated in a number of situations where their extraction of state resources that belong to the people in terms of their taxes is being questioned. So I'll be worried with that. And I hope we do not want to change this to a tribunal to try and look at such matters. And therefore, Chair, as I said, I agree that we shouldn't be going that route. We will be putting ourselves into unnecessary problems. If there's anything, Chair, we should be able to agree that the evidence leader should continue to do the work appointed for. At this point in time, even the terms of reference of her appointment have not been under question in the whole discussion we have been having. And therefore, let's continue and do the work that we are expected to do. And like I said, if I was a taxpayer, I'll still be asking the question, when you open another inquiry on a litigation in a matter with the Department of Forestry and so on, is it the mandate that you've been given by the National Assembly as the committee? Because we are now defocused. So I'm just saying, Chair, for me, that will really be the point. Let's move forward. There's nothing thus far that talks to anything in that regard that stops the inquiry and then take a detour to try and be another tribunal somewhere else. But the suggestion I'm also making, Chair, is that if the letters now, having been taught by events, if the letters can also be screened a bit when you receive them, try to get some background information so that we know if that letter really deserves the attention of this committee or not. Otherwise, tomorrow it's going to be on another member. I agree with that. Then is another one. In fact, by the time you think of it, it will be January next year. And you've done nothing in that regard. And we'll be raising matters that could have been raised if they were genuine right in the beginning as a way of protecting the process. But quite clearly, that's not the case at this point where we are. I want to submit, Chair, without getting to the other points in detail. Thank you.
Thank you, Honorable Maneli, for your contribution. Honorable Mautwe.
Thank you very much, Chair. Chair, let us state it categorically clear from the onset that we want to continue with the inquiry. However, we don't want to continue with questionable characters amongst us because this thing, Chair, is very, very crucial. And we must not take it lightly, like I hear my colleagues saying. So, Chair, I have said this before, and I will say it again, at the risk of sounding like a broken record. Chair, this is the first Section 194 inquiry. It is the first of its kind in a post-apartheid South Africa. Let's agree on that one. So therefore, this process is bound to be contested at times with too many interests that will require all of us at all times to be balanced and put aside our petty partisan mandate that are not in the interest of Parliament and definitely not in the interest of the public at large. Chair, if you remember my initial response to the application for your own recusal by the PP, I said that what was presented by the PP legal team needed you to appreciate that such a process will need all of us to have confidence that we did everything in our power to make this process appear as objective as possible. There must not be an instance wherein we are discussing presiding officers and evidence leaders
as the focus of the process and how we view the outcome. If we do that, Chair, our people will not have confidence on this process. And I still maintain, Chair, that this is an important objective that we must all seek to maintain and achieve throughout this process. You may think that the reasons advanced are nonsense and opinion, as I heard you in one radio interview. But the reality is that it is going to be impossible to look at the outcome of this process without serious questions. But this is now extremely important when it also involves the evidence leader, Chair. The terms of reference are clear about the role of evidence leader. It must be someone whose task is to assist both the committee and the PP to lead evidence, not in a biased manner. We have studied the submission by Godrich Gardi attorneys and the responses by Advocate Bauer. And our view is that whether the affidavit is this or that, as Advocate Bauer was saying earlier on, it does represent allegations and question the conduct that as the committee, we should not be subjected to the task of judging if it is material enough or not. For example, Chair, in some instances, it is not clear if Advocate Bauer is saying she did some of the things that are alleged for her to have done them, or she did not. She's not clear. Or some of the things are done, she thinks are acceptable, even though they are questionable. It is not clear what she was saying. Now, at some point, it sounded like Advocate Bauer herself wanted to complain about the complainant, because instead of addressing the allegation, she began to discredit the complainant. She went at length to try to discredit the complainant and not focusing on the allegations that are brought before her. All we need to do is to think and prioritize the integrity of this inquiry. Advocate Bauer must recuse herself, not because we are saying she's guilty of the allegations, but simply to allow the committee to arrive at a conclusion on time without challenges that could have been all avoided. That is what we are requesting, Chair. She must recuse herself. Simple suspect of wrong conduct and questions on involvement will lead us to wasting taxpayers' money. Some will take us to court and possibly we will be forced to repeat this exercise when it could have all been avoided. It should not be a matter of Advocate Bauer must remain as part of this inquiry at all costs. Even ourselves as the EFF Chair, we have raised the matter with the Speaker of the conduct of the legal team assisting the committee. For example, we witnessed here, all of us, a very disturbing scene here when Advocate Bauer passed a note to another committee member, which we believe was the name of our Deputy President, Commissar Floyd Shivambu. And soon after that note, Chair, the name of our Deputy President, Floyd Shivambu, suddenly popped up with insinuations of even criminal charges. Now, we are suspicious that that note that Advocate Bauer passed contained the name of our Deputy President. Chair, we are suspicious of Advocate Bauer's political motives, and we are saying for the sake of the committee and the time and the people of South Africa, since we cannot have another inquiry on Advocate Bauer, as that is the work of your own professional body and not us, she must recuse herself and allow us to continue with someone who no one is asking any questions about their characters. I know that, Chair, in the Zondo Commission, evidence leaders were paid close to 50,000 a day. So I'm not sure if it's got financial implications for her to want to remain here at all costs. But you are saying for the sake of the people of South Africa, for the sake of Parliament, for the sake of this inquiry, recuse yourself, ma'am. Let's have a clean inquiry that no one will question the character of anyone who's participating in this inquiry. I so move, Chair. Thank you very much.
Thank you, Honorable Maute, for your contribution. I now recognize Honorable Siwela. Honorable Violet Siwela. You are muted, Honorable Siwele.
Thank you, Chairperson. Thanks. Chair, by Advocate Bauer. Chairperson, I don't want to waste time. Really, this is quite disturbing because we started this process. Can you hear me?
Yes, you're cutting, but please continue. Honorable Siwele? I think she's frozen.
She's off the, oh yeah, she's frozen, sorry.
Okay, we might have to come back to her. Just mute her in the meantime, as I recognize Honorable Nodada.
Chairperson, can I come back?
Yes.
Chair,
Yes,
I was kicked out.
just
I'll
hold back
try
on.
to be brief, Chair.
Go ahead. Go ahead, Honorable Siwele.
Chairperson, what I wanted to say is that I'm worried about the way we are moving with this inquiry, because Chair, we started very, very well. We allowed Advocate Bao to lead us with other advocates. You were also doing your part very, very well, but all of a sudden, there are now a festival of letters which are coming forth here. I'm worried about the cost, I'm worried about the time, and I'm worried about even the integrity of this committee. My proposal, Chair, is that let us stick to the guidelines. Let us proceed in doing our work properly. I don't think that is quite reasonable to can say that Advocate Bauer should rescue herself. The recusal of Mrs. Bauer or Advocate Bauer will really indicate that we are not realistic, because even if we can give marks to all those senior counsel into this inquiry, I think she's one of the best who can top up because of her character, her soberness in doing her job. But today to come and say here she must move out because she's biased, blah blah blah. I'm really appealing to the members of this committee that let us protect this country by doing the right thing. We are not here to politicize. The end of the day, we're going to be told that we're using numbers. There is no issue of numbers here. We need to be realistic, and we mustn't punish a person without evidence. Advocate Bao, according to me, she's doing her work very, very well. Hence, I support her. I'm rejecting the application that she must be taken out, because there is no one who can perform better than she's doing. That's my submission, Chairman. Thank you.
Thank you, Honorable Siwele. Honorable Nodada.
Thank you so much, Chair. Chair, before I continue, can I ask if I'm audible?
Yes, you are.
Thank you so much. Chairperson, the first thing I want to state, it's a few factual points, first and foremost. Here we are members of parliament. And by virtue of being members of parliament, we are legislators, meaning that we are people that make the law. We are bound by the constitution that, by the way, was adopted by the very same parliament that we are in today. We are not a court of law. We are not people that are supposed to sit and determine allegations of criminality or any other form of law breaking for that matter. We are an institution that needs to play an oversight role in those particular entities. Now here we're sitting and discussing issues of allegations on matters that have no relevance whatsoever to this committee, number one. Number two, having no jurisdiction whatsoever as this committee to determine whether the allegations that have been put forward are actually valid or not. So those are the facts first and foremost on the table. So I feel as if, Chair, first and foremost, this is a waste of our time where we are dealing with applications that are put on the doorstep of this committee that actually don't belong here. And now this has required us to engage on matters, by the way, we have no jurisdiction to engage with. And there are some legislators that sit in this meeting They don't want to make a determination as if they are a court of law or they are legal practitioners that are supposed to process the matters that have been put forward. I've read through the whole response of Advocate Bauer based on allegations that have been made that the UDM and other applicants that have sent to this committee that rely simply on rumors, allegations that have nothing to do with this committee. And it's quite disrespectful to have honorable members and people that are sending things to this committee that actually have no bearing whatsoever. Now, Honorable Maneli raises something very important, Chairperson, and that's that when these issues, despite who is interested in the matter that we're dealing with as a committee, are brought to our attention, we must be very careful of entertaining things that we have no jurisdiction of, one. Number two, ensure that the things that are put on our table, actually we've got a legal obligation to deal with them. And they must pass the test of either our legal services to advise what the committee should be actually dealing with something like this. Now we're spending the whole morning talking about things, by the way, that are no relevant to this committee. Number two, wasting our time, honestly speaking. And thirdly, based on allegations and rumors that we have no business in dealing with. If somebody's got an issue with any person in this country, they've got the courts to go to. They've got the legal route to do that. And once those courts have made a determination as to what the outcome of those allegations are, if they are relevant to this committee, we can then deal with that. But to sit here and deal with rumors is actually really annoying. And members need to understand their role as legislators, and members need to understand the importance of this committee and the process that we need to follow is bound by the Constitution and the laws that we make in this House. So my proposal, Chairperson, is that we must accept the fact that Advocate Bauer has utilized her rights, legally so, not to recuse herself for whatever reasons that have been put on the table on matters that are not relevant to this committee. And I don't even want to go to the merits or the demerits of what she has responded to and what has been put to this committee. And we then make a resolution at this committee is that in moving forward in the future, whatever is put in this committee, one, must pass the test of relevance. Number two, we must be legally guided on whether it is relevant for us to deal with those issues so that we don't sit here and deal with allegations and rumors and people's emotions throwing tantrums around. Thank you so much, Chair.
Thank you, Honorable Nodada, for your contribution. Appreciated. Honorable Begizwe Ngosi.
No, thanks, Chairperson. Firstly, I agree and second Honorable Ngola and all other members on this issue. The matters raised really are not relevant, and they are before other courts or tribunals who can take decisions on them. And therefore, second, the motion by Honorable Ngola, supported by the rest of members. I just want to, Chair, latch on the issue raised by Honorable Maneli, whether ourselves as a committee don't have recourse really, or the National Assembly don't have recourse. I think I would request that, Chair, from where you are, you consider the following. One, request the Speaker through the relevant committee of the National Assembly to inquire from the Office of the Public Protector South Africa whether they've got a budget for legal fees, one, and two, how much of this budget is ring-fenced for Section 194 processes involving the PP. In the following financial years, 2021, 2022, 2022, 2023, and 2023, 2024. So that the Public Protector South Africa really tells us that can they stretch, can they afford to spend taxpayers' money on a strategy really that is meant to stall the process. Secondly, Chair, I want to also ask you to consider asking the Speaker and Parliamentary Legal Services to to do the following. Whether the National Assembly may not approach the Constitutional Court to ask for a declarator or a decision that compels the PP to utilize and exhaust processes of this committees, the Section 194 committee, before approaching any courts. Because I think that this approach of being in the committee and at the same time on the steps of the Western Cape High Court is very problematic. And we can't proceed as if we cannot ourselves as the National Assembly and as a committee approach the courts to compel participation by the public protector. And that also in that, consider to ask the public protector to avail herself of the extensive audit processes that have been provided here by this committee and exhaust this internally before she considers going to other tribunals before matters are resolved in this Section 194 committee. And this would be done, Chair, without limiting her rights. Thank you, Chairperson.
Yeah, thank you, Honorable Pegizwe Nkosi. All the contributions and the proposals are noted that you have made. I now recognize Honorable Kijimanis Kosana.
No, thank you very much, Chair, and greetings to all members and everyone present. Yeah, Chair, I would like to join other members in noting both the recusal applications that have been made by Honorable Holomisa and the Gadi attorneys, and also note the response thereof by Advocate Bauer, SC. Chairperson, my understanding is that recusal application in inquiries like ours should be made if there's a real or reasonably perceived conflict of interest, or if there is a reasonable suspicion of bias based upon objective facts. So, Honorable Chair, to the extent that the grounds captured on the two recusal applications are not directly related to this inquiry. However, they are based on matters that fall outside the scope of this inquiry. So on the basis of that, I agree with members that says that we should not accept these recusal applications, and also support the decision taken by Advocate Bauer not to recuse herself. Honorable Chair, it has been stated time and again, and I think Honorable Nodata captured that point, that we are not a court of law. We are not a court of law. So we don't have mechanisms, or we don't have a mechanism to deal with other matters like a court of law. Ours is only limited to the scope of our work, which is an inquiry into the fitness of the public protector to continue holding office. So if there's a recusal application, it should be related to our scope of work. I think in a month ago, we were dealing with a recusal application that was submitted by the public protector, where they were asking yourself and Honorable Mailham to recuse yourself from this inquiry. And in my view, that application was relevant because that application was dealing exactly with the work of the committee. They are saying you are perceived to be biased in the manner that you are sharing meetings, the decisions that you are taking and so forth. They say Honorable Milham is conflicted because of being married to Honorable Mazzoni and so forth. So I think that was the relevant application. But these other two applications that we are dealing with today, they are not relevant because they are dealing with other matters. They're dealing with matters that are outside the scope of this committee. No matter how serious those matters are, but the fact of the matter, they fall outside the scope of this committee. And that's this committee. We are not a court of law, and therefore we don't have a mechanism to deal with them. So there's no way that we can make a pronouncement whatsoever in relation to those particular matters, no matter how serious are they. Whether they are true or not is another matter, because I don't even want to go to the contents of the contents of the applications or the contents of the response by Advocate Bauer, because the fact of the matter, these matters are not related with the committee. In this committee, in this inquiry, Honorable Chair, we have had witnesses who appeared before the committee who self-confessed that they have been convicted in a court of law for one case or another, and others they've got pending cases in a court of law. But we couldn't say to them, we can't listen to their evidence on the basis of the fact that they've got pending cases in a court of law or they've been found guilty in one or two cases. But we allow them to present evidence because our interest is only limited to the evidence that relates to our work as a committee. Anything else which is not related to our work, we're not interested in. Whether a person's character is questionable or not, it's not for us to make a determination because our interest was on the work of the committee. So even those witnesses were allowed to make presentations in this particular committee because we were only interested on their evidence that relates to the committee. So if we are to deal with characters, it's going to be a very difficult matter to do. And I don't think we do have a mechanism as a committee to deal with that, to look at character of people and stuff like that, because we are not a court of law. So, Chair, I think I'm agreeing with members who say in future we need to look at applications that comes to us on the basis of relevance, whether is the application relevance, does it deal with matters that are before the committee before we can handle it. If an application, I think, is irrelevant, I think we don't have to entertain it. We just have to respond to the author of the application to say, but this application, as much as we're raising important issues, important allegations, but it's not relevant for our work. Maybe other structures or other organs of state or law enforcement agencies or court of law, whatever, they can deal with such things. But Tina, I think our scope is limited, so we won't be able to look at everything that members or other parties might want to place before this particular committee. So thank you very much, Chair.
Thank you, Honorable Gijimanis Kosana. On that note, that would have been the last end from the members. Perhaps just three areas to attend to. I'm going to ask Ms. Fatima Ibrahim to make brief remarks before I summarize and wrap up. But before that, if Advocate Bauer on very limited clarity is able to respond to some of the clarity sought, I'm going to ask her to do that. Advocate Bauer.
Sorry, Chair, maybe Ms. Ibrahim should go first because it might very well just cover everything that's been raised.
No problem. Ms. Fatima Ibrahim.
Good afternoon. Thank you, Chair, and good afternoon to the members and everybody else on the platform. Chair, I'm not going to deal with the merits of the allegations or the circumstances of the litigation matter. I think Advocate Bauer has covered that extensively, and that in any case, it's not my role to do so. But I will make some brief remarks in respect of what I think that the committee should consider or take heed of. Firstly, Chair, the rules of the Assembly never provided for the appointment of an evidence leader. Members will recall that following the Constitutional Court judgment that confirmed the Western Cape High Court's ruling that the PP must be afforded legal representation and a legal representative who would be allowed to participate in the proceedings of the committee. This committee then decided that it would be necessary for us to have an evidence leader. That was included in the terms of reference, and the terms of reference it dealt with the appointment, but it did not deal with the removal of the evidence leader. That being said, as the appointing body, this committee, of course, has the power to make a decision to so remove the evidence leader. So there would be nothing untoward or unlawful in making such a decision to remove the evidence leader. Chair, I secondly want to just comment on the nature of these so-called recusal applications or recusal requests. And I say so-called, Chair, because the legal concept of recusal relates to allegations of bias or conflict of interest. And such allegations are not being made here. Certainly, I cannot see that in the submissions that have been made. They seem to relate entirely to a litigation matter in which Advocate Bauer has found herself acting for one of the parties. And while she has made the links between that litigation matter and the current process before the committee, it does not in fact have any bearing on the work of this committee. There is no reason in law that I can see from anything of what's been submitted that would prevent Advocate Bauer from continuing as an evidence leader. The allegations made against her remain allegations, and there's no finding against her of having breached any laws, nor has she been convicted of any crime or found to have breached any ethical standards in terms of the professional standards that she's held by. It's also unclear as to how her continued participation in the process could pose any legal risks. And I say this because there has been no case made out for biasness or conflict of interest, which would have been the legal test that we would have applied. So what it seems to me to be is that what the requests, in fact, are removal requests based on the fear that her participation in the process because of these allegations might taint the process. So it's reputational in nature rather than legal. But from my understanding of what members have said so far, it seems that members have adequately grasped that. The role of the evidence leader has been clear from the beginning. As per the terms of reference, the evidence leader is not a prosecutor. The evidence leader is not a decision maker in this process. The role is purely to assist the committee by placing the evidence before the committee, but it's the committee itself ultimately that would need to weigh that evidence and determine what its recommendations will be to the Assembly. Chair, I'm not going to go through some of the other things that I've prepared because I think members have covered it. But it seems to me that the question, in fact, is whether members are of the view that based on these allegations, they have lost, there's a breakdown in the trust relationship with Advocate Bauer, and they feel that therefore she should be removed, that she would taint the process. And it's appearing to me from what I'm hearing that the majority of members don't feel that way. Nonetheless, members must take cognizance of what the allegations are. I think that they have. I've noted the proposal that we allow the complainants and then Mr. Kulu, whose affidavit forms the basis of the two complaints, an opportunity to come before the committee. Chair, I respectfully disagree. That litigation process has nothing to do with the work of this committee. The affidavit and what is contained there in those allegations must be tested by a court, and they will be tested by a court. It's got nothing to do with this committee at all. the mandate of this committee, in fact, is very narrow. Now, I note that the allegation against Mr. Kulu is that the monies that he's alleged to have taken relates to public funds. It may well be that the PC on environmental affairs would want to consider getting an update on this matter because it does involve public funds, but it certainly has nothing to do with the mandate of this particular committee. So we cannot allow an inquiry within an inquiry. Chair, I want to remind the committee of its constitutional obligation that this matter must be dealt with diligently and without delay. There have been various delays since the start of proceedings, and it is important that we keep focus and that we don't lose track on what we mean to be doing. That being said, Chair, should the committee wish to remove Advocate Bauer because they feel that they've lost trust in her, then they certainly can do so. But in so doing, it won't be based on any legal grounds, as far as I'm concerned. It would be a reputational issue and nothing more. Chair, those are my brief remarks. I don't know if there was anything else that I didn't cover, or if Advocate Bauer wants to add anything on her side. Thank you, Chair.
Thank you, Ms. Ibrahim. Before I proceed, Advocate Bauer, if there's anything you want to reflect on?
Yeah, I'm going to limit it to issues of clarification and not engage in a dialogue with anything that the members raised. There was a question raised as to how we made the link between the invoice that I indicated was before the committee and the reference to payments that have been made in the pending in the matter. There was correspondence that was tabled before the committee by the Secretariat. A copy of that invoice is indeed attached to it. This is evidence that we plan to leave through Mr. van der Merwe, but because of interlocutory applications, that evidence has now been delayed. But the invoice can be seen, and I know there's many attachments, so it may well be missed, but that invoice is indeed already provided to the committee. The second issue is this inquiry is being limited to the questions, or this committee's discussion today is being limited to the questions that have been raised in the communications put before the committee, to the extent that there's now been reference made to a particular note which everybody saw was being passed in an open hearing. That note lies with the Secretariat. The contents of it would be quite clear. Within minutes of that, I had a good chuckle with Advocate Mpofu about every kinds of nefarious motive that's going to be attributed to it. And the PP's legal team was invited by myself to go and have a look at how innocuous it was. I'm going to ask the Secretariat to make it available to all members so that that could be put to bed without any guesswork about what was actually contained on the note. I don't think there's any other issues that arose that particular clarification needs to be raised by me.
Thank you, Advocate Bauer. Colleagues, honorable members, and everybody, thank you very much for your contributions and interventions here. Perhaps by way of summary, colleagues, I think the first point to make would be to appreciate and perhaps ask all of us to appreciate that. I think the key issue you are raising is that we must stay focused on our mandate, keep our eyes on the ball. I think that point is taken firmly. But I want to say, as we do that, as we stay within our mandate and stay focused, I do want to urge members that and this is how I want to put it, that as we stay in focus and stay put into our mandate, we must have what I call listening ears, and we must have seeing eyes. In other words, ons kan nie oogklappies dra nie. We can't have that. We must be able to, whilst staying focused, also be seen that we are a listening committee. We do see things, and we attend to those things as we march forward with our task of executing this mandate, which is about the fitness to hold office of the public protector. I think we do have that ability to attend to that complexity of issues and navigate those issues. So nobody must feel that doors are closed, ears are closed, eyes are closed. We just don't want to hear anything else. We must have those listening ears and seeing eyes as we approach our task of testing this fitness to hold office. I want to emphasize that point. I think members are making a strong point that we must, especially from myself as the chair and the supporting team, our legal services and so on, that the next kind of request and correspondences must pass the test of relevance, so that we don't bore you with issues that we should have assessed, whether they should come to the committee or not, or in what way they should be attended. We take that task that we're going to have to do that work as you request us to do. Certainly, Honorable Mautwe, your point is taken. You've made a firm view about the need for us to protect the reputation of this committee and its integrity. And in your view, you thought that including when the chair, Mr. Milam, and now the evidence leader, it would have been better if we, in the interest of a reputational picture, that she recuses herself. That point is noted. However, having listened to everybody in this meeting, it is clear that out of those 14 members who would have spoken here, that about 12 of them are of the view that we do need. It's clear that firstly, the point being brought to this for recusal bears no relevance in relation to the work of this committee as a starting point, before you even get into the contents of what is being raised. That if you play cricket, there's something in cricket called leg before wicket. So if that happens, it doesn't matter what happened thereafter, whether this would have hit the ball or somebody would catch it. There's a starting point of relevance and the minimum requirement that you need to meet. And members are very clear that this application has nothing to do with the work of this committee. And therefore, as far as they are concerned, should not have been entertained. And as such, they support the decision of the evidence leader not to recuse herself and firmly reject, therefore, the application. And that would have been moved and supported by quite a number of members in that regard. I have taken note, Honorable Bekizo Ngosi, and between myself and the legal services, that's a matter we're going to have to pursue, of the kind of proposals you have placed here, beyond the matter that we're dealing with, as a way of protecting the constitutional work of us as legislators and the work of this committee. The points you've made in relation to what the certain things that we need to pursue and request, whether it is with the Justice Committee, which will be meeting today to consider coincidentally an annual report of the Public Protector South Africa, the issues that you are raising there in relation to that committee that plays oversight role. You you've raised issues that we need to be occupied with and see how far we go with those in relation to the issue of ensuring that all the Audi processes are exhausted in protection of the public protector for her to be afforded the opportunity, but also to ensure that her participation becomes sustainable in this process. And you'd have made points about further work that we might need to do in relation to other platforms and forums that would assist us in relation to that through the Speaker's office and so on. All of those points have been noted, perhaps as a homework that we're going to check how doable those things are. And therefore, in that regard, colleagues, in relation to what is in front of us, the decision of this committee is that we accept Advocate Bauer's decision not to recuse herself. We note the points raised about, the concerns raised about issues of reputation and the need to protect the committee as raised by other members. But the decision of this committee is that we proceed. We now need to proceed with our work. And you would have seen, you would have received actually today's agenda. You have also received an agenda for Thursday and Friday next week to indicate and that we are to demonstrate that we are ready to proceed with the inquiry to conclude the outstanding witnesses and therefore begin to look into the next steps of this process. I think that I want to say it up front. We're not just going to be concluding on it. It is already planned. In process, we would have communicated in that regard through correspondence with the public protector for their readiness around those kind of issues. With that, colleagues, I want to summarize that matter in that way before I ask Temingoso to take us through the correspondence quickly. But I see a hand raised there. Honorable Mautwe.
No, thank you very much, Chair, for recognizing my hand. Chair, just a quick one for me. I just want to put on record that this is not a majoritarian exercise. It must be noted like that. The importance and strength of democracy is the ability to hear the minority views when there is a slightest sense of truthfulness. So it doesn't matter whether 12 members said whatever they said and 2 members are saying something different. We still stand by our submission. Chair, can the objection of the EFF of your decision be noted by that the EFF rejects that? And can it also be please recorded in the committee report as such? I thank you.
No, thank you, Honorable Mautwe. In my summary, I would have noted and appreciated the points you have made. You've placed firmly of not supporting acceptance of this non-recusal. That's been noted, so there's no problem in us doing that. And the point here, it is not just about numbers. Each of the members that spoke when they were given an opportunity dealt in their own contributions with the detail and the contents of this response. They did not just raise hand and then said, count us and so on. So they dealt with the content of what is placed in front of us. So it would not be correct if there is such a perception that it was just a numbers game. It's an overwhelming view which is backed by clear articulations and argument in line with what is in front of us. I thought it's important, but your points are noted and registered as such. I would have raised myself in that way. Thank you, Honorable Mautwe. Colleagues, we proceed, we step off from this item. I want to invite, you are excused, Advocate Bauer, at this point in our meeting, as I invite Mr. Ngoma to take us to the last item.
Thank you, Chairperson. Good afternoon, and good afternoon, honorable members. Chairperson, as you have already indicated, that my role in this meeting for now is to table the correspondence before the community. On the screen, I have on the 18th of October, which is the Tuesday, received a letter from Sianejo attorneys regarding the recusal application of the chairperson and Mr. Milem, and requesting reasons for the recusal, for the refusal to recuse themselves and documentation thereof, which is when we responded on the 18th and provided that information to Sianejo, and also received another letter on the same day from Sianejo. The letter was talking on the notice of application for adjournment. Firstly, they were requesting appropriate time to study the documents that were provided to them, indicating that 72 hours would not be enough, as members would be aware that the plan was to have the inquiry proceeding today. And also indicating that they have a matter before the Western Cape High Court on Tuesday next week. And also, as I've earlier indicated, submitting a notice to file an application for adjournment of the committee. Those letters I have shared with members, and I think the committee will deliberate more, in particular the letter with that notice. And then, Chairperson, lastly, the letter on the 19th of October, which was then responding to Sianejo, just indicating that, acknowledging the receipt of their communication, which had indicated the notice of application of adjournment, and also indicating that the committee will then discuss the matter. But we had members, as would have seen, that we had made preparations, we have proactively requested next week, Thursday, if this committee agrees to deal with that matter. Chairperson, for now, I'd like to thank you very much.
Thank you, Mr. Tembebo Singoma. Just to conclude this correspondent part, I wanted to add, as I indicated at the beginning, that on the 5th of August, we would have received the correspondence from the chief whip of the EFF, laying a complaint about the evidence leaders in relation to matters whether they would have made additions to Mr. Samuel's affidavit and matters that were not brought to the attention of the PP team. I did ask the evidence leaders to respond to that, which they have. And therefore, having received that, I will be forwarding a response correspondence to the EFF immediately after this to indicate the outcome of that. I just thought I must just add, because that letter would have been tabled last on Monday when we dealt with this. So thank you very much, colleagues. That's the correspondence that we have today. If there's no other matter, question, or response to that, or clarity, it will signal the end of our session today, so that we begin to start joining to be ready for the 2 o'clock sitting. Thank you, colleagues. I see no hand, therefore, in that regard. Thank you very much for your participation and for your contribution in directing the work of this committee. It's a novel process. You're navigating a lot of issues that are complex. I really appreciate that I am able to work with this team that is so diverse in their thinking and their intervention. Thank you very much, colleagues. The meeting is adjourned.
Thank you, Chair. Long live the Chair. You can smile now. You're doing very